So I can wear this, and I have the pleasure of teaching a 4-hour class today. So having lost my voice, I'm very grateful for the assist here. But I'm very grateful for that kind introduction, Oren, thank you. And even more so for the invitation to be here at Bar-Ilan, where I'm teaching a water law class. I think some of my students are with us. And it has just been, there they are, a delightful experience. So I'm just delighted to be here. And as I have mentioned to some of you, very thrilled to be here in Israel, which is known throughout the world as such a leader in the management and conservation of water resources. So it's very exciting for me to be here learning about Israeli water management at the same time that I can share something about US water management. But I'm especially happy to be able to share today one of my favorite stories, not just of water law, but my favorite stories of all time, which is the story of saving this place here, Mono Lake. Mono Lake, as Oren mentioned, is it's a beautiful and remote water source in Northern California on the edge of one of our most beloved national parks, Yosemite National Park. And the story I'm going to tell today may have some similarities to the situation in Lake Kinneret. It will also have some differences, and I will be grateful for my colleagues who are going to be joining us afterwards to discuss some of them. But the story I'm going to tell is the story of how some important legal doctrines came to play in the United States to resolve a water conflict over use of water resources in Mono Lake. And that conflict involved a very important legal doctrine, the public trust doctrine, which, as some of you may know, is a common law doctrine, a very ancient common law doctrine, with roots as far back as ancient Rome, that sets forth public rights, perhaps public property rights, in certain resource commons, especially waterways. Nevertheless, this public trust doctrine can come into conflict with private rights that people like to associate with water within those waterways. And this produced a conflict that resulted in a very important case in the United States. That is the story of the Mono Lake case. The case is called National Audubon Society versus Superior Court, better known as the Mono Lake decision. It was a 1983 decision by the California Supreme Court resolving a conflict over water between the great city of Los Angeles, our second largest city in the United States, some 10 million people live there, and advocates for the Mono Basin, the Yosemite National Park's eastern watershed. And that case set forth important public trust principles that have come to influence the development of this doctrine throughout the country and indeed throughout the world, in nations as far distant as India, who have come to rely on this case to see their own water law unfold. In my remarks today, I am drawing on a 2015 Law Review article that published the backstory to this case, and I was then invited to turn that into this book that I am working on now. So, Oren, thank you for inviting me to share it. Here is my plan. Okay. Someone else has a different plan. Okay, there it is. This is my plan for the talk. I'm going to begin by introducing the public trust doctrine and tracing its roots through early Roman and British common law. Then I'm going to flesh out what the doctrine means through two classic stories of American environmental and water law. One is the Supreme Court's decision 100 years ago in Illinois Central Railroad, and then in more detail, the Mono Lake case, National Audubon Society. I will conclude by foreshadowing some new developments of the doctrine in the United States, seeing it applied in the context of groundwater regulation, fracking or hydraulic fracturing for natural gas, and even in the context of climate change, where we'll finish up. I don't think we'll have time during my remarks to talk about this, but perhaps in Q&A, I challenge you to think about what this case that I will tell you about tells us about the role and the scope and the content of this doctrine in terms of what promises is it making, what balances does it require, what limits does it put on other uses of water, and who gets to make these decisions. So you can think about that as we talk about the case. The last thing I'll say before I begin is that this case is not just of academic interest to me, because I was a forest ranger at Mono Lake in the immediate aftermath of that California Supreme Court decision, and this was the case that inspired me to go to law school and eventually become a lawyer and a law professor. And so it's with great pleasure I can return to it now as an academic and tell the story. But let us begin at the beginning, and the beginning is very old. So the roots of the common law public trust doctrine go as far back as ancient Rome. In the Institutes of Justinian, the Byzantine Emperor Justinian I codified the jus publicum principle of Roman common law this way. By natural law, these things are common property of all: the air, the running water, the sea, and with it, the shores of the sea. Now I want to mention, we're going to spend a lot of time talking about its application to water. But do note the first item in the list, which has to do with the air. Thank you, Shai. We will come back to this at the end of the talk. So the air, the running water, the sea, and with it, the shores of the sea. Now this idea originates in Rome, but it came to my country, the United States, through British common law. You also have some experience with British common law. And it goes back as far to the Magna Carta in 1215, which set forth sovereign, perhaps public rights to waterways and even forest resources. For example, Chapter 33 required the removal of all weirs or obstructions, piers or docks, in the Thames, the Medway, these are great rivers, and throughout all of England that interfered with fishing or navigation. It also shows up in early British common law, setting forth sovereign rights and later perhaps even responsibilities with regard to coastal tidelands. In 1611, the King's Bench held that navigable waters were owned by the sovereign for public use, though non-navigable waterways could be privately held. There is a scholarly critique of this early account of the public trust doctrine that says the Americans overstate its reliance on British law. The Magna Carta wasn't about public rights, it protected a few rich barons. And if there were responsibilities in the king for waterways, that didn't happen until late into the 19th century. Now, I take no position on whether this historical critique is accurate or not. Either way, this is a story Americans have been telling ourselves for a very long time. We began to tell this story as far back as the early 19th century, when state courts quoted Justinian and the limitations of the trust on the English crown in holding that the land beneath navigable waters was common property. And the famous quote, which I'll read, is this one: "The sovereign cannot, consistently with the principles of the law of nature and the constitution of a well-ordered society, make a direct and absolute grant of the waters of the state, divesting all the citizens of their common right. It would be a grievance which never could be long borne by a free people." And so this statement of public ownership of waterways probably resonates in Israel, where water itself, I understand, is publicly owned. The US Supreme Court begins to make reference to the doctrine in 1842, referencing back to the Magna Carta to affirm the sovereign ownership of navigable waters and submerged resources. It says the policy of England since Magna Carta for 600 years has been carefully preserved to secure the common right of piscary for the benefit of the public. And in 1894, it definitively establishes that when territory comes into the United States by whatever means, submerged lands will be held for the benefit of the whole people and in trust for the people. So this is the story of its development in the United States, where it developed not only in application to coastal tidelands, seawater, seashore, as in England, but to all navigable waters, because we have so many great rivers that are used for navigation and other purposes. This is the definitive statement, but 2 years earlier, the Supreme Court decided a case that is the most cited, the most famous of all, Illinois Central Railroad. I'm going to read its description, and then we're going to talk about the facts of this case. So in 1892, the Supreme Court held, or described, that the state holds the title to the lands under navigable waters in trust for the people of the state, that they may enjoy the navigation of the waters, carry on commerce over them, and have liberty of fishing therein freed from the obstruction or interference of private parties. And that's the rule that most states applied in their common law. What we see here is the doctrine evolving in two important ways, not only as a grant of sovereign authority over waterways, but also as a limit on sovereign power, because the state holds these resources in trust for the people. The people are the beneficiaries of the trust, and those people can enforce their rights in court if they feel like the state, as trustee, has fallen down on the job. So to see what that means in practice, let's look at that very case from 1892, Illinois Central. It's a complicated case, but I can boil the facts down very simply the following way. In 1869, the state legislature of the state of Illinois gave the bed of Chicago Harbor in Lake Michigan, one of our Great Lakes, huge lake. I think this lake might be bigger than Israel. Yeah, it's a very big lake. The state legislature gave the bed of Chicago Harbor to a private railroad for economic development. The people of the state were not delighted. They voted the legislatures out of office. A new legislature took power. The first thing they did was to repeal the conveyance. Now the railroad was not delighted, and litigation ensued. The railroad's argument, as any toddler would frame it, was very simple. They said, no backseas. You can't just give us a very valuable natural resource and then take it back as though that gift never happened. There are all sorts of problems with that. Perhaps you can imagine some of them, shyster. The state said, we understand your concern. Had we given you this gift and then just taken it back, we understand there would be all sorts of problems raised there. But we think there is really no problem. Because really, argued the state, there was no gift. The state relied on the public trust doctrine to say the bed of Chicago Harbor is a navigable waterway. It's protected by the public trust doctrine. We hold it in trust for the people. That means, while it may have looked like those state legislatures gave you a gift, they didn't really give you a gift. It was beyond their power to do it. So no gift happened, and therefore we are out of trouble. And the Supreme Court agreed with that interpretation, and therein was the first and most powerful use of that doctrine. Now I want to mention that the common law doctrine has also been adopted constitutionally by many states. They've added the principle to their own state constitution. Sometimes it looks familiar, like the common law version. This is Florida's constitution. The title to lands under navigable waters within the boundaries of the state is held by the state by virtue of its sovereignty and trust for all the people. It looks very familiar. Sometimes it has been modernized and expanded. For example, the Pennsylvania State Constitution, which says the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. So a much more expansive version of the doctrine. Now, so far, I have given you a public commons account of the public trust doctrine that protects waterways in trust for the public. It's a public commons theory. Everyone shares ownership of the resource. But there's a separate body of law that we also need to think about that will, as we'll see, come in conflict with the public trust doctrine, and that's the law of private water allocation. So as my water law students know, because we spent all day talking about it, in the United States, individuals can claim rights of use to the water under two separate rules. In the eastern United States, they use a doctrine called Riparian Rights. It's the British rule. Roughly, under Riparian Rights, everyone has to share. So it's also a public commons theory. But in the western United States, we use the doctrine of prior appropriations and beneficial use. And if we boil this one down to a nutshell, the rule is first in time, first in right. It's much more of a privatization model of water rights. And that privatization model really has trouble fitting in with the public commons model of the public trust doctrine. So here's our problem. The public trust doctrine establishes a public commons model of public rights in waterways, whereas the private prior appropriations doctrine takes a privatization approach to the water within the waterway, but it's all the same water, right? These theories developed as though they had nothing to do with each other. These two different lines of law developed completely independently, and they don't fit very well. They were inevitably destined for a collision, and that collision happened most spectacularly at Mono Lake. So let's trace the story of what happened there. And the story begins with a problem that will be familiar to you in Israel, the problem of water scarcity. So in California, here's a picture of the city of Los Angeles. 10 million people live in the greater Los Angeles, as many as are in Israel altogether, more. 10 million people living in the greater Los Angeles area. The Los Angeles River, the major surface water resource, has about enough water for maybe 100,000 people. So that's a big overdraft, 10 million, 100,000. For that reason, moving water to the city of Los Angeles has been a priority of the state since 1906, when they finished pumping out all the groundwater and it was gone. Necessity is the mother of invention. So this map shows where all the water in California is. It's mostly coming off of the Sierra Nevada mountains in the north. And here's Los Angeles with no water anywhere to be seen. So these red snaking lines are the aqueducts that the state has built to bring water to the city of Los Angeles. And we're going to talk about the very first one to be built, the Los Angeles Aqueduct, that goes all the way up to Mono Lake, which is roughly parallel to San Francisco. Mono Lake was not the first place that Los Angeles looked to for water. Los Angeles is down here. Mono Lake is up there. Halfway between is an improbable oasis in the Southern California desert called the Owens Valley. There's water there because it's sandwiched between two mountain chains that funnel water into the Owens River and what used to be an enormous lake at the base of the river, the Owens Lake. When Los Angeles came to build the aqueduct, it loved the idea of going to the Owens Valley because even though it was 200 miles away, it was 4,000 feet of elevation higher than Los Angeles. And that meant that they could build a miracle of modern engineering, a 200-mile-long aquifer that would pump water over 2 mountain ranges. Here's the aqueduct, bringing water all over the coastal range just by the force of gravity alone. So it was very exciting. There was a problem. There were already people with water rights in the Owens Valley. It was a thriving agricultural community. And this is a wonderful story that I don't have much time to tell. I'll just say Los Angeles may not have behaved at its best in securing those water rights. Los Angeles essentially tricked the farmers into giving up their water rights by pretending to be farmers. And they bought up all the water rights, and only after it was too late did the farmers realize that they were really not just selling their farms to a neighbor, but they were losing all of their water 200 miles to the south. And indeed, the farmers did not go quietly. They dynamited the aqueduct. The National Guard had to be called in. It was kind of a big thing. But at the end of the day, Los Angeles had secured its rights, and all the water was taken. First the surface water, then the groundwater. When Los Angeles was done, what had once been a thriving oasis in the desert was a big hole in the ground with toxic alkali salt flats on top. So not only was there no water and all the people had to leave because there was no water, the winds that whip off the side of the mountains would churn these dusts, these alkali salts into the air at a rate that makes it the most polluted place in the United States on a particulate matter basis. And worse than that, it's cancer causing. So everyone left there, got cancer, and died, or left. So nobody lives anymore in the Owens Valley. It's a very sad story. On the other hand, Los Angeles got its water. It's a big city and needed water. 40 years later, Los Angeles realized it needed still more water. And there was more water to be had, just another 200 miles to the north. And so the aqueduct, Los Angeles began to look to Mono Lake. And let me introduce you briefly to Mono Lake. So Mono Lake is not really a lake, it's more of an inland sea. It's twice the size of the city of San Francisco. At 3 million years old, it is the oldest continuous lake in North America, perhaps tied with Lake Tahoe nearby. It's 3 times saltier than the Pacific Ocean. It's had 3 million years to gradually erode salts from the surrounding mountains into the basin. Water flows in, but has no way of flowing out. It only evaporates off the surface, leaving the salts behind. So it has become so salty that even fish cannot live there. It is sometimes compared to the Dead Sea, California's Dead Sea, said Mark Twain. And for that reason, it has a unique ecosystem. It's been a site of important scientific research, stunning natural beauty, and importance to the culture and the communities that live there, including the Kuzetica Paiute, who have lived there for generations. There are no fish in the lake, but it's teeming with life because it has 4 trillion of these guys, these tiny shrimp. And if I were to take a coffee cup like this one and scoop lake water out of it, as I did every day as a forest ranger, I would have between 10 and 40 shrimp in my cup. That's how rich they are around the shores. So Mono Lake is a big bowl of shrimp soup. And for that reason, it attracts millions of migratory birds from around the world following the Pacific Flyway from the Arctic all the way south to Latin America. Species of all sorts of different birds. There's an island in the lake. The lake has 2 islands. In this picture, oh look, it's me. No, really, the picture is about this. This little black island is the nesting ground for 85% of all of California's population of California gulls. And those islands in the lake are part of the youngest volcanic range in North America. On the south side of the lake are these 10,000 foot tall volcanoes. The Mono craters are a scientific research destination for studying underwater volcanism, and our space agency, NASA, has even used Mono Lake because of its interesting chemistry to research what extraterrestrial life might look like on other planets. So a few years ago, Mono Lake made news because NASA thought it had discovered a wholly new form of life, one that was based on arsenic, the poison, instead of phosphorus, a building block that all the rest of us, life on Earth, has. And it was very exciting until they could not reproduce the results. So we don't know. We don't know if it's true or not. In any event, Yosemite, as I mentioned, the lake is the eastern watershed of Yosemite National Park, a very beautiful, beloved park. The water from Yosemite flows down the eastern flank of the mountains into Mono Lake. These freshwater creeks that feed Mono Lake are critical regional fisheries. They provide critical riparian habitat, important cultural values. What Mono Lake is not is a population center. So the town on the side of the lake, where I used to live, Lee Vining, has only a couple of hundred people, as opposed to the 10 million people that live in Los Angeles. There's a little local industry. There's a pumice mine in the volcanoes. There is a brine shrimp plant where they sell the brine shrimp as fish food. But by far, the most important industry are the national and state park public lands that bring hundreds of thousands of visitors from around the world to visit the beautiful lands. And there we are, the hardworking rangers of the Eastern Sierra Public Lands. This was my house. This is the ranger station at the base of the Yosemite crest. It's very beautiful. And right across the street from the ranger station was this sign: City of Los Angeles, private property, no trespassing. So decades before I ever showed up in the 1940s, Los Angeles succeeded in acquiring all of the water rights and much of the land rights in the Mono Valley, and they did it in a much less notorious way than the Owens Valley. They didn't trick anyone to pretend to be a farmer. They just said, we really need that water. We see all this water being wasted, just flowing into the lake. We're going to take that water. We'll buy it from you if you have rights. If you don't want to sell it to us, we'll just take it from you using our power of eminent domain. And it did. It still needed the permission of the state water agency to move that water so far away. And when they asked, the water agency was very concerned. They said, we feel really bad about this. We know what happened in the Owens Valley. This looks a lot like the same thing could happen here. We feel really bad about that. But there's nothing we can do. Los Angeles is a big city. They have lots of people. They need the water. There's nothing we can do about it. Sorry, Mono Lake. And the licenses were granted. 30 years later, Los Angeles needed still more water. There was still more water left in the Mono Basin, so they built a second aqueduct, paralleling the first, the second barrel. At this point, LA was importing 20% of its water from the Mono Basin. Mono Lake began to precipitously crash, perhaps like Lake Kinneret has done. So in 1962, before the second barrel, the lake had already lost 25 vertical feet, and these limestone tufa structures that are normally below the surface began to be exposed. 6 years later, this maybe 12-foot tall tower is now exposed at the base. Another few years later, after the second barrel went in, the lake has now lost 40 vertical feet, half of its volume, and that same tufa tower is a mile from the shore. Eventually, Mono Lake loses 45 vertical feet, half of its volume of water. And this is an image of what it looked like before the second barrel. You can see the Nedged Island is beginning to be bridged to the land by exposed lake bed, and the lake is beginning to shrink. And this is a picture of what it looked like after the second barrel. Now Nedged Island isn't even an island. It's just bridged to the land. There's this white bathtub ring of alkali salt. The same air pollution problems in the Owens Valley have begun to happen in the Mono Valley, which is now in violation of our Clean Air Act because of this problem. There were terrible impacts to the ecosystem. As the lake level fell, as the lake lost half of its volume, the remaining salts were still there, so it doubled in salinity. It stressed the shrimp, they turned red, they couldn't reproduce. The birds would come and starve because there were no shrimp. The creeks and fisheries were desiccated. The local economies began to suffer and public health began to suffer. And it was at this point that a ragtag bunch of locals decided to try to save the lake. And those ragtag locals, the Mono Lake Committee, were eventually joined by state and federal NGOs, non-governmental organizations, also agencies. They all were interested in this lawsuit, and the lawsuit was brought around the public trust doctrine. So let me introduce to you the case, and we'll review it quickly. The claim that the plaintiffs made was, Mono Lake is a navigable waterway protected by the public trust doctrine. That means, state of California, you hold it in trust for us. You can't just give it away. The public trust doctrine is prior to all other legal considerations. The diversion licenses that the state granted to LA were in violation of the public trust because it's like giving away Chicago Harbor. You're giving away this public resource. You have no right to do it. You have to take it back. LA defended the lawsuit vigorously. They said this is not about the public trust doctrine. This is about the prior appropriations doctrine, the private water allocation doctrine under which we established property rights. Our private rights of appropriation trump the public trust doctrine because, after all, the public trust doctrine is a common law doctrine, and our water rights are based on statutory law, and the normal relationship between the common law and statutory law is that where they conflict, the statute trumps. So private appropriation has to trump the public trust doctrine. And anyway, this is nothing like giving away Chicago Harbor. We're not a private railroad making a profit. We're a city providing water to our citizens. So that's a terrible analogy. The California Supreme Court said to them, you're both wrong, except for the ways that you're both kind of right. Both of these doctrines are very important, but neither one, said the court, trumps the other. California law merges these areas of law. What that means, significantly, is that the prior appropriation statutes did not abrogate the public trust, which we'll talk about in a moment. That's an unusual feature. It's an unusual common law doctrine. But it also said the state can't neglect its duties under the trust, so it has to reconsider the licensing to balance Los Angeles' legitimate needs for water against Mono Lake's environmental values. It gave it back to the water agency. The water agency spent 10 years and in numerous public meetings and scientific inquiries establishing a balancing point between, and they basically chose a compromise level. This was the original lake level. The orange line is where it was at the time of the court. The red line is where it was going. The water board said the lake has to get back to this dotted line level. When it does, that will stabilize the salinity and protect the ecosystem. It will cover the salt flat and protect public health. It will protect the scenic and recreational values at stake. And once the lake reaches a certain level, Los Angeles can still take water. But we just have to make sure that the lake doesn't disappear. It was a compromise. I want to give credit to Los Angeles, because after that moment, everyone thought Los Angeles would just appeal the water board decision, and it didn't. Instead, very much like the Illinois Central case, the people voted in new city leadership. And the new city leadership finally decided to try something that you were all very good at, conservation. And by implementing vast water recycling and conservation infrastructure, they were able to make up the entire loss of Mono Lake just through conservation. So 3 cheers for Los Angeles. Now, I'm going to wrap up. Oh, well, I'm going to show you. So it worked. This picture I showed you earlier was in 1996. You can see the land bridge is sort of reaching out towards Nedget Island. 2 years later, the land bridge is itself an island. It's beginning to be submerged again. Things were looking good, but then by 2015, it looked like that again, because there was a big drought. And then by 2017, it looked like that. It's been going back and forth. It's never actually reached the designated restoration point. But it's on the way, and Los Angeles is able to divert some water. So let's sum up. I want to review the important precedent of the case and some important critiques. The important legal innovations in the case was first what we mentioned. The public trust doctrine was not displaced by the prior appropriations doctrine, which is surprising given the usual relationship between common law and statutory law. It's surprising, but perhaps it makes sense, because if we think of the public trust doctrine as a constraint on sovereign authority, the sovereign is bound by an obligation to the people, then it makes sense that the sovereign can't just legislate its way out of that obligation. It makes the public trust doctrine a quasi-constitutional kind of common law, a very unusual kind of common law. Though I should acknowledge at least one state has rejected that. Nevada has rejected that interpretation and has gone in a different direction. We can talk about that later, perhaps. The Mono Lake case affirmed that the public trust doctrine applies not only to the traditional values of navigation and commerce, but also to ecological, environmental values like scenery, recreation, and ecosystem. It extended the doctrine from the navigable waterway itself to the non-navigable tributaries of the waterway. After all, Los Angeles didn't want the water in Mono Lake. Too salty. Imagine trying to desalinate that. They were taking the water from the freshwater creeks. And the court said if we don't protect the creeks, there's no way to protect the lakes, so that was extended. And recently, that same principle, just 2 months ago, was extended to groundwater resources in California. So that's been an important extension. Finally, it articulated a duty of ongoing oversight under the public trust doctrine that says the state can't just one time make a decision and be done. It has to always be thinking about its obligations under the trust. And that's what allowed the Water Board to revisit its past licensing decision from the 1940s, but suggests that they might have to revisit other decisions, or even this decision again in the future. I've given a heroic portrait of the doctrine as something that saved Mono Lake, but not everybody loves the doctrine. So in particular, the property rights community in the United States really hates the public trust doctrine because they're concerned that it puts a fist on the scale in favor of public rights at the expense of private rights where they conflict. And they're worried about what the limiting principle would be for a doctrine that seems so malleable in time and in scope. The legal process critique worries about the separation of powers implications of a doctrine that allows the judiciary to second-guess the legislature and wonders if the doctrine is anti-democratic. Even most environmentalists love the public trust doctrine because of the Mono Lake case, but some don't and think it's a mistake to use the vocabulary of property law, trusts, ownership, to do a job that stewardship ethic would be better for. So the big environmental statutes of the United States came about at this time, the Clean Water Act, the Clean Air Act. They think it's a mistake to turn to property law. We should rely on a stewardship ethic that just says protect the resource because you should. This is my last slide, and here's where I'm going to conclude. After Mono Lake, people tried very hard to use the public trust doctrine in all sorts of different directions. Success was mostly limited to waterways. So most of the time the doctrine protects waterfront access, shoreline access, river access, lake access. Recently it's been extended to groundwater, as I mentioned. It's also been extended in Pennsylvania to protect drinking water sources from hydraulic fracturing activities. But many scholars have asked, why not apply the same doctrine to other critical commons resources that are also susceptible to private appropriation and monopoly? For example, why not fisheries? Why not biodiversity? Or most compellingly, perhaps, why not the air? You'll remember at the beginning of my talk, I told you to remember in the Justinian quote that the first item on the list was the air. So right now, in the United States, and there are partner lawsuits around the world, there's a movement to use the public trust doctrine to sue governments for failing to regulate greenhouse gases on the theory that they're giving away the harbor by allowing polluters to use the atmosphere as a carbon sink. They're giving away the commons that belongs to future generations, and most compellingly, these suits are being brought by children, youth plaintiffs who have been suing, saying it's our future generation that's being denied. So this week in Oregon, the most important of these cases goes to trial, Juliana versus United States. It was scheduled to go to trial yesterday. It's been delayed by a petition of mandamus, but it's going back to trial. So we will see where that goes. But at this point, I look forward to hearing from my colleagues here in Israel about what parallels there may or may not be to the Israeli situation. Thank you.